Hi, this is J. Sai Deepak. I'm a practitioner of intellectual property law before the Delhi High Court. I am currently a senior associate with Sai Krishnan Associates. I've been working with this firm for the last 5 years. The module that I'll be handling is the module on patent infringement. This is more or less a crisp module which focuses more on aspects of patent litigation as opposed to patent jurisprudence, which is why the assumption is the readers of this particular module are fairly at home with patent jurisprudence. The content of this particular module relies on references to provisions from the statute and its interpretation, and case laws have been used only to the extent that they are relevant for the purposes of understanding the provisions that have been dealt with. When we speak of patent rights, the first thing that needs to be understood is what is the scope of the rights granted by the Patents Act to a patentee, and this is dealt with by section 48 of the Patents Act. Section 48 of the Patents Act, as most people already are aware of, grants exclusionary rights which are negative in nature, which means the patentee has the right to exclude all third parties from acts of making, selling, offering to sell, importing, so on and so forth, which do not have his consent. In stark contrast to the standard notion of property, this is not a positive right which is meant to bestow upon the patentee the right to practice something. It is the right to exclude third parties. This is the nature of rights under section 48. Now, as far as section 48 is concerned, it comes with its own set of limitations, and these limitations are more or less conditions contingent to which the right under section 48 can be enjoyed. For instance, section 47 prescribes that the government need not take the permission of a patentee in importing the patented products and using it as part of its dispensaries, as part of its hospitals, if the patented product is a pharmaceutical product. Nor does it need the permission of the patentee to store or sell the patented product through notified dispensaries as well. There are a host of conditions under section 47, including the conditions for research. Now, these conditions not only act as limitations on the right of a patentee under section 48, these also act as prospective defenses if a third party is sued by the patentee for infringement. Now, one of the things that's interesting about the Patents Act 1970 is that although it grants a right, it expressly disclaims any presumptive validity owing to the mere factum of grant. Simply put, just because somebody has got a patent, there is no presumption that the patent has been validly granted. Therefore, it is perpetually open to attacks, it's perpetually open to challenges, it's perpetually vulnerable to challenge by any party by way of a pre-grant, by way of a post-grant opposition or revocation subsequent to the grant. Now, section 13(4) has also been interpreted by the Supreme Court in the decision of Vishwanath Prasad Radheshyam versus Hindustan Metals, where the Supreme Court has interpreted section 13(4) to mean that despite the fact that a patent may have undergone rigorous examination during the course of its prosecution by the Indian Patent Office, it does not translate to any form of validity, which means the evidentiary burden is on the patentee whenever he seeks to assert the patent in a court of law. So, for instance, if the patentee were to institute a suit for infringement, the first step that he has to cross, or the first barrier that he has to cross, is to prove prima facie that the patent that has been granted to him is valid in the first place. Unless and until this aspect of the patent is covered, it is practically impossible and legally impermissible for the patentee to proceed to the second aspect of his case, which is prima facie case of infringement. Now, this is in stark contrast to, let's say, other forms of intellectual property such as the Trademarks Act, where under the Trademarks Act section 31 clearly states that a trademark that is registered shall be treated as prima facie valid, which means it is the defendant's burden to disprove or to challenge the validity of the trademark that has been granted. Now, this has serious implications in terms of enforcement for a patentee, because even if the patent may have been granted 4 or 5 years after its prosecution and examination of a by the patent office, it does not in any way hand him the ability to claim prima facie validity or presumptive validity. Although courts have developed certain principles in case laws where they have come out with propositions to the effect that if the patent has been in force for about 6 to 7 years at least a considerable period of time, or if the patented invention has been practiced by members of the industry for a significant amount of time, or the patented invention has been licensed to a significant number of people by the patentees, the court may venture to treat the patent as having proven its validity over a point of time. Be that as it may, the question remains whether courts are allowed to build such safeguards or checks or balances which appear to be extra statutory when there is an express provision such as section 13(4) which disclaims presumptive validity and which does not seem to leave any windows open, or which does not seem to provide for these kind of contingent recognitions of validity or conditional recognitions of validity. Now, this is something that an Indian court has not had an opportunity to address so far, but it's hoped that at some point these will be addressed. So, once we have a right, the question is what are the metes and bounds of the right positively and negatively. When I say positive metes and bounds, I refer to limitations on the patentee which keep open the realm of commons for all third parties. And when I speak of negative bounds of or negative conditions, I refer to those instances where a third party has crossed the threshold of the realm of commons and has entered the territory of infringement. Unlike the Copyright Act, which specifically enumerates those actions which would amount to infringement or which would constitute infringement, the Patents Act does not have a single provision that spells out what would amount to infringement of the patentee's right under section 48. Therefore, one can assume, and this would be a logical and legal interpretation or a legal conclusion to arrive at, that anything which amounts to the exclusive right of the patentee under section 48, and if such an activity is undertaken by a third party without the consent of the patentee, it would amount to infringement of the patentee's rights under section 48. As far as infringement is concerned, there are 3 or 4 aspects of infringement which have immediate bearing or relevance as far as the patentee is concerned. Point number 1, the moment the patentee comes to be aware of or has been notified of the infringing activity, what is the remedy that is available to him? Which is the forum that he can appear before or he can approach to seek a redressal of his grievance? What kind of reliefs are available to him? How does he establish jurisdiction, so on and so forth? The first thing that needs to be understood is, unlike the Trademark Act and or the Copyright Act, the Patents Act does not contain a special jurisdiction clause which bestows a right on the patentee to institute a suit for infringement at a place of his business or where he resides. Therefore, he is left to fit his case or establish his case within the Code of Civil Procedure, which otherwise governs the conduct of civil suits in this country. Therefore, the patentee will have to establish that he has either a cause of action at a particular place, or he has to institute the suit at the defendant's place of business or where the defendant resides. Simply put, the patentee has to establish jurisdiction on the basis of section 20 of the CPC. Now, this actually is something that could form a potential constitutional ground because there is no apparent reason why a patentee or patent owners in general have not been bestowed the same kind of special jurisdiction clauses, have not been bestowed with such special jurisdiction clauses which are otherwise available to copyright owners and trademark owners. If the idea is to extend a benefit such as this to small authors or authors in general, so that they may be in a position to take action against an infringing party at a place of their convenience, surely this is a benefit or a relief that can also be extended to patentees, because at the end of the day, patents need not be owned by large corporations, they may be owned by individuals or small entities. Therefore, this is one thing that seems to be amenable to a writ challenge or a constitutional challenge at some point in the future. It is surprising that this has not been agitated in the court, considering that this anomaly has been existing in these legislations for quite some time, at least for the last 5 or 6 years. As far as reliefs in a suit for infringement are concerned, reliefs are governed by section 108, and these are typical reliefs, which is an injunctive relief, relief of damages, or rendition of accounts, delivery up, seizure and destruction of infringing goods. Now, section 104 of the Patents Act spells out the forum that he may appear, and it actually goes on to say that a patentee cannot approach a court which is lower than the district court to institute a suit for infringement. Now, section 104 has 2 aspects to it. It first of all spells out the court or the forum that a patentee is entitled to approach to institute a suit for infringement. It also contains a proviso which goes on to state that the defendant in a suit for infringement, if he chooses to challenge the validity of a patent by way of a counterclaim under section 64, then both the suit and the counterclaim for revocation would be transferred to the appropriate high court for consolidated adjudication by the high court. Now, this is a feature that has a historical basis, and there seems to be a policy call behind this, and for this one has to refer to the Iyengar committee report, which went on to state that whenever there is a challenge to the validity of a patent by way of a counterclaim or a revocation petition, it will be the appropriate high court which shall be seized of the matter, which is why this particular provision continues to be in force despite the constitution of the Intellectual Property Appellate Board. Now, since we have already touched the issue of counterclaim, I'll have to refer to certain aspects of the defendant's rights. Whenever the defendant or a defendant is sued for infringement, there are 3 or 4 options that he may mix and match, so to speak, depending upon the objectives that he wants to achieve. So, for instance, it is possible for the defendant who has probably received a notice for infringement to file revocation petitions before the Intellectual Property Appellate Board or post-grant opposition under section 25(2) if he is within the requisite time period, which is a period of 1 year from the date of publication of the grant of the patent, as a preemptive action to challenge the validity of the patent before the patentee has the opportunity to institute a suit for infringement. Now, what this does is it creates a certain cloud on the title of the patentee or the validity of the patent, and in a way it helps the defendant prevent the grant of any ex parte orders or interim reliefs pending the disposal of the revocation petitions before the Intellectual Property Appellate Board. In the alternative, it's also possible for the defendant to file revocation petitions subsequent to the institution of the suit for infringement and raise the revocation petition as a defense under section 107 before the court which is seized with the suit for infringement. In the alternative, it's also possible for the defendant to institute counterclaims as a counterblast to the suit for infringement, so that the court which is seized with the aspect of infringement is also seized with the aspect of validity. Now, from these options, what comes out or what follows is that the framework is such that there is a possibility for bifurcated litigation, which means there could be instances where one forum is seized of the issue of validity of the patent, which is the IPAB, and another forum is seized with the issue of infringement of the patent, which could be a district court or a high court, as the case may be. Now, in a situation such as this, one would have expected the framework of the Patents Act to provide for a certain provision which envisages the sequence of events in terms of which of these actions will proceed first and which of these fora will have to hold its hands, so to speak, until the other forum is done with its adjudication. For instance, if there is a pending challenge against a patent before the Intellectual Property Appellate Board, one would have expected the legislature to provide something on the lines of a section 124 of the Trademarks Act in the Patents Act. Section 124 of the Trademarks Act provides for stay of the suit proceedings before a court when there is a rectification petition challenging the registration of a trademark before the Intellectual Property Appellate Board. Now, what this does is to ensure that the court does not proceed to enforce the patent only to realize at a subsequent stage that it has actually enforced an invalid patent, which would have actually caused irreparable harm to the defendant or considerable harm to the defendant, even if it is not irreparable. Although the absence of section 124 in Patents Act seems to suggest that such a provision was never intended by the legislature, while it was intended for the Trademarks Act, it could always be argued that a court has the inherent power to not enforce a patent on the ground that there is an outstanding challenge to the validity of the patent, and in light of that outstanding challenge, it ought to err on the side of caution to not enforce the patent until there is an outcome one way or the other in the revocation proceeding or the invalidation proceeding before the Intellectual Property Appellate Board. What also needs to be understood is that there could be instances, and these instances happen with such frequency, where the defendant merely files a revocation petition before the Intellectual Property Appellate Board merely to create a doubt over the validity of a patent and to prevent the grant of an ex parte injunction, when the fact of the matter is the revocation petition may not have any merit whatsoever. Now, the option in such a situation before the court, which is seized of the issue of infringement, could be this. The court could look into the credibility of the revocation petition before the Intellectual Property Appellate Board, take a prima facie view of the same, and then decide whether or not the revocation petition is strong enough to prevent the grant of an interim injunction, or is it so frivolous that it does not merit looking into and that it does not warrant refusing the grant of an interim injunction. Now, this is, I think, a much more balanced way of handling a situation such as this, because then the court has had an occasion to apply its mind, at least on a prima facie level, to the invalidation challenge, and then doing justice to the matter, as opposed to simply treating a mechanical filing of a revocation petition as the be all and end all of the matter of the grant of an interim injunction. Apart from instituting counterclaims or revocation petitions to challenge the validity of the patent before the Intellectual Property Board or the court that is seized of the issue of infringement, the defendant has certain other options which have been provided for under the Act. The first of which would be section 107 under the head of defenses to a suit for infringement. What this provision basically does is this: it gives the defendant the option of not filing revocation petitions or counterclaims under section 64 and merely raising defenses by invoking the grounds under section 64 to challenge the validity of the patent. So, in practical terms, how does this work out, or how does this play out? So, when a defendant is called upon to file the written statement in response to the plaint of the patent in a suit for infringement, what the defendant could do is to basically, first of all, respond to the allegations relating to infringement, and also raise defenses under section 107 by invoking grounds of invalidation under section 64. So, apart from having raised those defenses, the defendant is also expected to cite prior art to support each of those defenses. Now, the difference between a situation where the court is seized of a counterclaim and a suit for infringement, and where a court is merely seized of a situation where the defendant has raised grounds under section 107 without filing a counterclaim, is this: in the former, the court has the power to revoke the patent since a counterclaim has been filed seeking revocation of the patent, whereas in the latter, it is not the revocation that is sought. Instead, what is sought is non-enforcement of the patent in light of the defenses or the grounds of vulnerability that have been pointed out by the defendant. Therefore, although this appears to be a technical difference, this is a very real limitation on the power of a court to revoke a patent if the defendant does not institute a counterclaim for the revocation of a patent before the court. As far as section 107 is concerned, one of the questions that could be raised is, or this is a question that can also be raised with respect to section 64. Is it possible for a defendant to go beyond the grounds which have been provided for under section 64 or 107 to challenge the validity of a patent? The answer has to be a straightforward no, for the simple reason that section 64 makes it abundantly clear through its language that the grounds that have been provided for to challenge the validity of a patent under the provision are exhaustive in nature. Since section 107 limits itself to the grounds that have been provided for or enumerated under section 64, it is not possible for a defendant who invokes a defense under section 107 to go beyond the grounds that have been provided for under section 64. This aspect of the issue has been interpreted by the division bench of the Delhi High Court. In fact, it was done way back in 1996 in the case of Franz Xaver Humer versus New Yash Engineers, where it was sought to be argued by the defendants that it is permissible for them to go beyond the grounds of section 64 when a defense is raised under section 107. Interpreting both the provisions, the court arrived at the conclusion that since section 107 refers to or incorporates by reference section 64, the grounds of section 64 circumscribe the grounds of or the defenses that are available under section 107. Does this mean that it is impermissible for a defendant to raise grounds which are not available under section 107 or section 64? No. Should the defendant place reliance on issues or facts which go beyond section 107, then it is possible for the defendant to place a combined reliance on section 107 and those aspects which are foreign to 107. What it simply means is that if the defendant chooses to place reliance or invoke section 107 alone, then he cannot introduce grounds or facts which are alien to section 64. However, if he chooses to use section 107 as one of the defenses available to him in a suit for infringement, then he can use grounds which are not available under section 64 as well. So, for instance, if there are aspects related to a patentee's conduct either before the patent office which are not necessarily grounds of revocation under section 64 or in the market which are not necessarily grounds under section 64, apart from raising grounds under section 64 and reading them along with 107, it is absolutely within the rights of the defendant to point out to those aspects of the patentee's conduct which have a bearing on aspects of equity, which in turn have a bearing on the grant of an interim injunction. So, for instance, if during the course of the examination of a patent or a patent application, the patentee chooses to not comply with the directions issued by the controller or the examiner to rectify certain objections, and yet somehow the patent office goes on to grant the patent, it is permissible for the defendant to point to those aspects of the patentee's conduct and seek refusal of an interim injunction on the ground that the improper examination of the patent, although not a ground for revocation under section 64, certainly gives rise to a certain element of doubt with regard to the grant of the patent, and therefore the court should not or ought not to enforce the patent. Now, the court could ask itself a simple question: if a certain ground or a certain aspect does not ultimately translate into a ground for revocation of the patent, on what basis can a defendant place reliance on it to prevent the grant of an injunction? Here is where an alternative remedy needs to be discussed. Assuming that a patent has been granted in compliance with, at least in letter, of all the provisions of the Act, but still ultimately militates the object of the Act one way or the other, it is potentially open for a defendant or a third party to file or institute a writ petition seeking the interference of the writ court in a situation where a court cannot otherwise revoke the patent or any other forum cannot otherwise revoke the patent using statutory grounds. So, one instance could be this: if a patent application was taken up for examination after the expiry of the term of the patent itself, would it be possible for a third party to challenge the examination and subsequent grant of a patent on the ground that although there is no express provision under section 64 to challenge the grant of a patent on grounds that it has been granted or examined after the expiry of its term, it could still invoke a writ petition as an option to challenge the validity of a patent? This is something that has happened in the past, where the patent office has taken up applications which have expired and has gone on to examine and grant those patents after the expiry of the term. In such a situation, it can be nobody's case that merely because this is not a ground for revocation under section 64, the public or third parties have to suffer the continued subsistence of the patent on the register of the patents. Now, this is insofar as the grounds of defense, the grounds of defenses to a suit for infringement is concerned. Another interesting defense which warrants serious attention is section 107A of the Patents Act. Section 107A has two aspects. The first of which is known as the Bolar exemption, and the second is popularly projected as the parallel import defense, which I humbly beg to differ with. As far as the first Bolar exemption is concerned, it provides that it is absolutely within the rights of a third party to use a patented invention to the extent that the use is restricted to generation of regulatory information to bodies inside or outside India or for the purposes of research. As far as the second defense is concerned, which is section 107AB, the popular assumption or the myth, at least in my opinion, is that section 107AB refers to parallel imports, and it permits a defendant to import a patentee's product from a foreign jurisdiction without attracting allegations of infringement. My humble submission is that this is a policy based reading of the provision, which has got nothing to do with the actual language of the provision or the legislative history of this particular provision. I have written in detail on this particular aspect of the issue, where I have gone on to say categorically that section 107 has got nothing to do with parallel importation by way of international exhaustion. The problem with the interpretation or the popular conception is it assumes that parallel importation is only by way of international exhaustion, and there can be no other legal means to import parallelly the patented product. If one were to look into the legislative history of the amendment of section 107AB in 2005 and the parliamentary debates on this issue, it actually points to a different scenario where all that the provision permits or empowers the government to do is to give the rights to manufacture the product to a foreign party so that the product may be imported at a cheaper price, and this is to be done in a situation when there is absolutely no domestic party who is in a position to manufacture the patented product through the compulsory licensing mechanism. In other words, this is a reverse or the converse of section 92A. Now, this is a discussion for another day. Be that as it may, I would fervently and sincerely request readers to pay attention to section 107A and follow the debate on this particular provision, because it has serious implications for public interest as well as for the rights of the patentee. Whichever way this may go, ultimately what one must understand is that there cannot be any policy based discussion on a statutory provision without reference to the language of the provision, without reference to those permitted aids which help us understand the actual import of the provision. Therefore, if one has to really understand the provision, and assuming that there is an ambiguity in the language, then the maximum that one can go to reduce this ambiguity or to eliminate this ambiguity are internal and external aids of interpretation, but policy arguments cannot be used to advance a position which does not find any resonance with the language of the provision. Now, this is with respect to the defenses. The one thing that I would urge students of patent law to understand is that ultimately patent law is law, although it is law that deals with science. In which case, whenever we discuss patent infringement or patent litigation in general, it is important for students to first of all be at home with certain aspects of litigation, which is procedure, which would mean a fair amount of familiarity with the Code of Civil Procedure and the Evidence Act. Besides that, it is strongly urged that students are completely at home with doctrines and principles of equity, which are frequently used and which are frequently relevant in any litigation, and patent litigation is no exception to this proposition. Therefore, anybody who is interested in taking up patent litigation as a choice of career, I would seriously urge them to start understanding principles of property first, elements of property jurisprudence first, principles of equity first, before they proceed to understand patent law, because at the end of the day, patent law is not a peculiar exception to principles of property jurisprudence or equity, which have been well settled for all these years and centuries. Therefore, if one has to seriously understand the subject in all its in a very comprehensive fashion, the approach cannot be to read the Patents Act alone in a blinkered fashion. There has to be a conscious effort to tie this with other aspects of general litigation, such as constitution, because there is also the element of access to medicines that has to be understood from a constitutional standpoint, the right to health, the right to life, so on and so forth. Plus, there has to be an effort to understand how do equitable principles, when it comes to grant of equitable reliefs such as interim injunctions, play out in the context of patents. Is there a significant departure when it comes to patent law? To summarize what I have said, no discussion of the Patents Act is complete without a reference to the Act and the express provisions and the language of the provisions. That said, no understanding of the subject as a whole is complete without reference to general principles of property and general principles of equity. Thank you.